right, well, welcome everybody. Thank you for being with us. I hope you are well, and we're delighted to have you here. My name is Andrew Guzman, for those who do not know me. I'm the Dean of the Gould School of Law, and I am delighted to have the chance to welcome you to USC Gould's U.S. Supreme Court Preview event. We're thrilled that you can join us virtually. We love the online format, though, like everyone else, we can't wait to be able to do all of these events in person again as soon as possible. Before we get started, I have a couple thank yous. First, I want to thank our Development Alumni Relations Office, in particular, Shahoy Reed and Margaret Keene from that office, who've helped to put this together. I also want to thank our events office, who never fail to bring together these events and have everything run smoothly. So thank you to them, all of those folks, for organizing today's event. So one of the many things we do at Gould that we take pride in is creating opportunities for learning that feature the great minds in the legal profession. And we like it even better when those let us bring together our students, our staff, our faculty, our alumni, and all our other friends of the law school. That is our entire community. And today's event falls squarely in that category of an event that appeals to our entire community and that has two really terrific speakers. Some of you may remember that our Supreme Court Preview was a favorite annual event for many years, and we're thrilled to be bringing it back now by popular demand this year. And needless to say, the docket for the Supreme Court this term is not lacking in interesting cases. So both the speakers and the Supreme Court docket promises to make this an interesting session. So let me not stand in the way. I'm going to do a quick introduction of our panelists and then turn it over to them. Our first panelist is Professor Rebecca Brown, who holds the Rader Family Trustee Chair in Law here at Gould. She teaches courses in constitutional law and theory. She clerked for Justice Thurgood Marshall of the U.S. Supreme Court and served as an attorney advisor in the Justice Department's Office of Legal Counsel before starting her academic career at Vanderbilt Law School. She joined USC in 2008 and is currently working on a book commemorating the contributions of Justice Marshall to constitutional jurisprudence. Our second panelist is Dean Erwin Chemerinsky, who is the Jesse H. Choker Distinguished Professor of Law at Berkeley Law School. He was the founding dean of the University of California Irvine School of Law from 2008 to 2017, and now obviously is the dean at Berkeley Law School. More important than any of that, he has long and deep roots here at USC, where he taught for more than 20 years. In fact, I know that some of our guests in the audience had him as a professor, and those who didn't have him as a professor quite likely read from one of his many books. Dean Chemerinsky is the president-elect of the Association of American Law Schools. He's written many books, including a very recent one, Presumed Guilty: How the Supreme Court Empowered the Police and Subverted Civil Rights. He's also argued several cases before the Supreme Court. Margaret Keene, who is from our Development Alumni Relations Office, will be monitoring and assisting with the Q&A, so you'll be hearing from her as well. The format for today's event is pretty straightforward. Our panelists will have a conversation between the two of them for about 70 minutes. And then after that, questions for the audience will be welcomed and taken. You're invited to use to submit questions using the Q&A feature at the bottom of your Zoom screen. And so I will now do the most important thing I have to do, which is get out of the way and turn it over to Professor Brown and Dean Chemerinsky.
Wonderful. Thank you so much, Andrew and Margaret, for making this happen. And I just am thrilled to really be talking to my friends out there, students and alums, friends of the law school, colleagues. And I am especially thrilled to be sharing the small screen here with my friend Erwin, who is always full of interesting things to say about the Supreme Court. And I'm looking forward, as much as you are, to hearing him get started on sharing his observations with us. We don't have a very formalized layout, but I'm just going to start with a few thoughts as an overview, and then I'm going to, sorry, I'm going to turn off the noise maker here. Then I'm going to let Erwin start off with some thoughts of his, and then we'll start talking about some of the cases. We're eager to hear your questions. We're excited to be talking to you, even though we can't see your faces. We're looking forward to that maybe next year. But here are a few thoughts that I wanted to share about the docket coming up. There's so much that's obvious and that's been discussed in the newspapers, and I don't really know if I'm going to say anything that you haven't already thought of. We're definitely in uncharted territory here, with the 3 Trump appointees on the bench in a position to exert a significant influence on the court, in conjunction with the already established 3 existing conservative justices. So for the first time in our lifetimes, there seems to be a solid 6-3 conservative majority. And the question really is, how will that make the decisions from the court look different from what we've experienced in the past? But I want to inject just a touch of complication into that rather simple picture and suggest that we do have a little bit of room for uncertainty here. Erwin may disagree with me on this. I'm interested to see if he does. But because as important as ideology is, there's also a dimension that we sometimes refer to as judicial philosophy, or something in that vein, that is also extremely important in how a justice votes or writes an opinion. And that is, in particular, what I'm thinking of is whether a justice is someone who believes in making incremental changes in the law, step by step, kind of one case at a time, or rather a jurist who sees themselves more as a maximalist, purely ideological, fighting for the right answers and the right, what they view as the right solutions to problems. So while there are 6 conservatives on the court, they are not all the same along that dimension. This could make a difference when we're thinking about areas of constitutional law that are currently in the crosshairs for change. Chief Justice Roberts, we all know, has shown a desire to blunt the political appearance of the court, has often joined the liberals, in fact, or created narrow opinions, even when he disagreed, in order to avoid what he saw as decisions that damaged the legitimacy of the court. We've seen Justice Kavanaugh, too, occasionally moving into a position that gives him greater relevance by taking small steps in some cases. Indeed, last term, the statistics tell us that he was the justice most often in the majority, which really was a surprise to some of us. 97% of the time, he was in the majority, which suggests that he is emerging as the new swing justice. And that is a position both of power and of responsibility, which sometimes has an impact on the way justices think, because they can hold out their votes in an effort to shape decisions, to keep them small or narrow or controlled to some degree the direction in which they go. And this summer we saw Justice Barrett stop short of overruling a precedent that she said she disagreed with, because she said she wasn't ready to know what would replace it. That's a sort of a minimalist tendency or an incremental tendency in a religious freedom case. So these little glimpses suggest that there is still some taste among those in the majority to preserve a sense that they are a court, not just politicians in robes ready to grab power and use it as soon as they have it. And this difference shows up especially in how committed a justice is to respecting precedent. The minimalist will try to nudge the law in new directions, trimming it at the edges, but preserving its core because it is precedent, not necessarily because it is correct, while the maximalist will be salivating to overrule broadside things they disagree with and issue new constitutional rules. So sometimes a minimalist justice will actually join a majority in order to have control over who writes the opinion, or other ways in which they can rein in tendencies of their more maximalist colleagues. So while many like to emphasize the extent of agreement amongst the justices, a sort of a juggernaut, unstoppable, heading in certain predictable directions, I am keeping my eye on the granularity of that apparent consensus and hold out maybe some hope that those in the new center will sprinkle this newfound power that they clearly have with a dose of humility and respect for an institution, such that change can be well considered, careful, perhaps incremental, and even maybe surprising us, as justices have done in the past. I should say that I'm not going to go to the mat on that prediction. However, I'd love to hear what Erwin thinks about it, because I see the grants of cert that this court has already made for this term as an indication that they are taking on big questions, and they may be, in fact, rarer to go big. But the cert, remember, the cert grant only takes 4 votes, not 5. And so each individual justice's sense of their own role, their own sense of appropriate behavior for the court in minimalist or maximalist ways will make a difference in how they go, how they vote on those cases. So Erwin, how about you? Some thoughts?
Thank you. It's really a joy to be part of this conversation, Rebecca, and it's a great pleasure to be back in a program for USC. I wish we were in person, but it's great to do it this way. As I was saying before we started, I spent 21 wonderful years on the faculty at USC, and it's always be a very special place for me, and I'm delighted to be part of any program there. 2 years ago, October term 2019, was Justice Ruth Bader Ginsburg's last on the court. And everyone noted that the justices were split. 4 liberals, Ginsburg and Sotomayor, very liberal, Breyer and Kagan left of center, they're not quite as much. 4 conservatives, you had Thomas, Alito, Gorsuch, and Kavanaugh, and that left John Roberts in the middle. He was the swing justice, and it was truly the Roberts court. I think statistics in that term are particularly revealing. That year, the Supreme Court decided 53 cases with signed opinions after briefing and oral argument. 14 were 5-4 decisions. In 10 of the 14, the majority was Roberts, Thomas, Alito, Gorsuch, and Kavanaugh. Now, had Barrett been on the court rather than Ginsburg, those likely would have been 6-3 decisions, not 5-4 decisions, because from everything we know about Barrett, from her writings as a law professor, from her time on the Seventh Circuit, from her months on the Supreme Court, she's quite conservative. But it wouldn't have changed the result in those cases. There were 2 cases that term that were 5-4, where the majority was Roberts, Ginsburg, Brierson, and Kagan. They were important cases. One struck down a Louisiana law imposing restrictions on abortion. Another of them said that President Trump acted improperly in rescinding DACA, the Deferred Action for Childhood Arrival program. Those cases likely would have come out different had Barrett been on the court rather than Ginsburg. So after Justice Ginsburg died last September 18th, after she was replaced by Justice Barrett on October 26th, I felt there were 2 predictions I could confidently make about the Supreme Court. There would be a lot more 6-3 decisions than we had seen previously, because there were 6 conservative justices appointed by Republican presidents and 3 liberal justices appointed by Democratic presidents. And we would see very few 5-4 cases where the liberals were in the majority. Now they would need to get 2 votes rather than 1. They have to get 2 from a court that has 5 staunch conservatives in Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. Those predictions came true last year. There were 12 6-3 decisions and 6 5-4 decisions. And some of the most important cases of the term were 6-3. The Supreme Court decision that gutted Section 2 of the Voting Rights Act, Brnovich versus Democratic National Committee, was 6-3. The Supreme Court decision that expanded the takings clause and limited union power, Cedar Point Nursery versus Seed, was 6-3. A decision in the last term that made it harder for states to regulate not-for-profits, America's Prosperity Foundation versus Bonta, was 6-3. And I give many more examples, obviously. And there were no cases last term that were 5-4 where the liberals were in the majority, where we would say it was an ideologically defined issue. So as we approach this term, that's the reality. 5 very conservative justices, 1 moderate conservative, and 3 justices appointed by Democratic presidents left of center. I think Rebecca's right that even among conservatives, there's a difference in the extent to which they want to be minimalist or maximalist. Also, there's a difference in how much they care about precedent. Clarence Thomas has written in Judicial Opinions that precedent shouldn't matter at all. Amy Coney Barrett wrote law review articles saying precedent shouldn't matter at all. The justices just follow originalism. and 3 justices on the current court, Thomas, Gorsuch, and Barrett, are self-avowed originalists, believing that the meaning of a constitutional provision is fixed when it's adopted and can change only by amendment. But the bottom line is, it is a very conservative court. Clarence Thomas and Samuel Alito are as conservative as any justices who have served on the Supreme Court, certainly in the last 100 years. And when you look at the justices that Donald Trump picked, he was selecting to please the far right. Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett are all very conservative justices. So I liked listening to Rebecca's optimistic prediction that maybe they'll be minimalist and maybe they'll follow precedent. When my grandmother's alive, she actually did use the phrase, "from your lips to God's ears." I am much less sanguine about that. I think that in the areas where conservatives really care, such as the ones we're going to be talking about, I think that the conservative majority is going to change the law and change the law dramatically. And also, I think it's important as we begin this discussion to keep in mind that the current conservative majority is not likely to be a short-term phenomenon. Amy Coney Barrett was 48 years old when she was confirmed last October 26th. If she stays on the court until she's 87, the age was Justice Ginsburg died, Barrett will be a justice into the year 2059. When she was sworn in, Gorsuch was 53, Kavanaugh 55, Roberts 65, Alito 70, Thomas 72. I've long thought that the best predictor of a long lifespan is being confirmed for the Supreme Court. After all, Justice Stevens didn't retire until age 90. So I expect that we're going to have a very conservative court for another decade or two, maybe more. I don't know if you want to talk more by way of overview, if I should start talking about specific cases in the area of religion in the court.
Yes, why don't we take a topic near and dear to many of these justices' hearts and talk about what you think they're going to do with the religion clauses this term. Maybe start with Carson.
The area where it's most clear there's a dramatic shift in the Supreme Court is with regard to the First Amendment religion clauses. For decades, the Supreme Court said that the prohibition of laws respecting the establishment of religion was best understood through a metaphor of Thomas Jefferson, there should be a wall separating church and state. Now we have 6 justices who reject the idea that there should be a wall separating church and state. 6 justices believe that little violates the Establishment Clause. The government violates the Establishment Clause only if it coerces religious participation. And now we have a majority on the court that clearly wants to have robust protection for free exercise of religion, even when it means creating exceptions from general laws, such as the anti-discrimination laws. There's 2 religion cases before the Supreme Court this term. One was granted in the spring, the other was granted just a couple of weeks ago. I want to talk the one that was granted in the spring, Carson versus Macon. For so many decades, the issue was, when may the government give aid to parochial schools without violating the Establishment Clause of the First Amendment? The government would want to give some form of assistance to religious schools, and the question is that permissible or is that an Establishment Clause violation? Now the issue is completely different. Now it's, when is the failure of the government to give aid to religious schools a violation of free exercise of religion? We've gone from what used to be the question of when may the government do something to now being when must the government do it. In 2017, the court decided Trinity Lutheran versus Comer. Missouri had a plan of giving aid to schools for surface of playgrounds. They gave the aid to public schools and secular private schools that qualified. They didn't give the aid to religious schools because of provision in the Missouri Constitution that prevented direct or indirect aid to religion. The Supreme Court 7-2 ruled against Missouri. Chief Justice Roberts wrote for the court. Justice Sotomayor wrote the dissent, joined by Justice Ginsburg. And Chief Justice Roberts said, to give this aid for playgrounds to secular private schools, but not to religious schools, violated free exercise of religion. Justice Sotomayor, in her dissent, said, this is the first time in history the court has ever said the government is required to give aid to religious schools. But Chief Justice Roberts, in footnote 3 of the opinion, said, this is a narrow case, just about aid to playgrounds. We saw in June 2020, it wasn't narrow at all. The case was Espinoza versus Montana Department of Revenue. Montana adopted a law that gave people tax credits if they gave money to a school tuition organization. It was money to go to private schools. Almost all the private schools in Montana are religious. The Montana Supreme Court found that this violated the Montana state constitution. I would have thought that would have been the end of it. A state Supreme Court found a state law to violate the state constitution. But the Supreme Court reversed 5-4. Chief Justice Roberts writing for the 5 conservative justices. And Chief Justice Roberts said, whenever the government gives aid to secular private schools, it is constitutionally required to give the aid to religious schools, unless doing so would violate the Establishment Clause. As I said, for them, relatively little violates the Establishment Clause. This is the context for Carson versus Macon. There are many places in the state of Maine that don't have public school systems. They're too rural to be able to sustain a public school. So in these areas, there's a school administrative unit, and it provides money to parents to send their children to private school. The money can be used for any secular private school, but it can't be used for, quote, a sectarian school, a religious school. Challenge is brought, arguing that to deny the use of the funds in religious schools violates free exercise of religion. On the one hand, perhaps this is different from the earlier cases. The earlier cases involved so-called Blaine amendments, which were thought to be motivated by anti-Catholic bias. Maine's prohibition has nothing to do with that. Also here, Maine has good reason for not having public schools in certain areas and having to use this kind of program. On the other hand, I think the Supreme Court in Trinity Lutheran and Espinoza has made so clear whenever the government gives money to secular private institutions, it must give that money to religious institutions. So that would seem to indicate here the court's more likely to rule against Maine.
Yeah, it seems to me there's a really, I mean, obviously, Erwin has laid the groundwork for what I'm about to say also, but that there's a big theoretical shift, probably already has happened, or maybe it's in the process of happening, regarding when the court thinks it's appropriate to intervene aggressively and, on behalf of a religious issue, and not to defer it all to legislatures. With constitutional theory, that's always our question to some degree, right? When in theory, our first resort is legislators, and we want them to do what they can do as a first resort, but we have the courts as a backstop. And so the question, of course, is when do the courts have to come in to be that backstop to protect individual liberties and other provisions of the Constitution? And members of this current court have been suggesting frequently in lots of different kinds of cases, not even including necessarily religious exercise cases, but sometimes in free speech cases and in others, that those people in our country who have religious beliefs are a persecuted group needing the court's protection. I haven't said it, I don't believe in so many words, but they've implied it. And the language in the cases is very reminiscent to me of the way that the Warren Court used to talk about racial and other vulnerable minorities. A jurisprudence that is very characteristic of them now. That's how we speak about the Warren Court, that they viewed themselves as obliged to step in to protect those for whom the legislative process could not do it or was not doing an adequate job of protecting them. That's been called a representation reinforcing theory of judicial intervention. And it really means you protect those whose interests are not taken seriously enough by the legislature. And back in the Warren Court era, to the extent that was used in religious cases, mostly it was for fringe religions. those who were often viewed as unpopular or subject to persecution of various types. Many of our older pro-religious freedom cases, for example, involved Jehovah's Witnesses or Christian Scientists or Native American religions who didn't have mainstream views of conduct. And those special things they wanted to do or not do were not always viewed, happily by the majoritarian legislatures, and the court stepped in to protect them. But this really resounds more in equality than it does in religious liberty as such, right? This is a question of equal treatment of groups doing similar things. And so what is new to me, or relatively new with this court, is that that principle is being applied to the dominant religion in the United States, which is Christianity, even though it has great resources and great influence. And so you have to somehow decouple the theory behind representation reinforcement from this view that this group deserves the court's special protection and special attention. So, because this court does believe that religions are subject to being treated less favorably than other groups. And it seems to have been given rise to this idea that Erwin mentions, that is to say, anytime anyone gets an exemption from a law or a benefit from the state of any kind, religious groups have to be equal contenders for those exemptions or those benefits. And so I think a case like this one, that the Carson versus Macon case, will play right into that belief system, right? It's going to look to through that lens as if there's a persecution, unfair treatment, unfair exclusion going on, and that therefore that will, just reinforce this pre-existing tendency to look at the cases that way, and the court will strike down the restriction, I think. Do you want to mention the Ramirez case, or should we move on?
Sure, I can do so very quickly. There were a couple of Supreme Court cases 2 years ago that involved whether or not somebody who was being put to death had a right to have a clergy member there. And what Ramirez involves is somebody who was facing death who wanted not just a clergy member there, but a clergy member to be able to lay hands on him. And the question is, was the state's denial of this an infringement of free exercise of religion? And it came to the Supreme Court on the so-called shadow docket, asking the Supreme Court to issue an emergency ruling in favor of the person who condemned death. And the Supreme Court stayed the execution, granted cert in the case, and said, let's have it briefed and argued soon. So it's an interesting procedural way that it came to the court. And I think what's interesting underlying this is it pits two themes of the Roberts Court against each other. One is, as we've talked about, it's very inclined to protect free exercise of religion. The other is, it's very hostile to claims of prisoners. And it'll be interesting to see with the tension between these two, which wins out.
And am I right, Erwin, in that the court has not always been as hospitable to these types of execution chamber religious claims by members of other religions? So there's a little bit of ironing out they're going to have to do if they're going to have new rules about religious liberty. Am I right about that?
Yeah, and I think this goes to your more general point that the cases of the 1960s, 1970s were about the Supreme Court protecting much more minority religions. Now the cases are much more about whether the Supreme Court is going to protect the Christian religion. And so how will that play out here, where you're dealing with a minority sect within a larger religion?
Great. Okay, well, I think it's time on that note to start talking about the obscure and little discussed issue of abortion. It's on the forefront of everyone's mind, and there's speculation everywhere. I don't have a lot to offer in the way. I have my own ideas, but we'll see. Let's just see what we want to say about it. On December 1st, the court will hear arguments in a case called Dobbs versus Jackson Women's Health Organization, a case, excuse me, testing the constitutionality of a Mississippi law that prohibits abortions after 15 weeks. The single issue that the Court of Appeal, that the court granted, is phrased as whether all pre-viability prohibitions on elective abortions are unconstitutional. That's the only question presented on which they granted. And the state forthrightly answers that question, no, right? Whether all pre-viability prohibitions are unconstitutional, the state says no, they are not. And so because Roe and Casey hinge on viability and set viability as the point dividing the place where the state can ban abortions outright from the time when they can't at viability, and viability is usually considered to be 23, 24 weeks. It seems that this is just an absolute head-on attack on the precedent of Casey in particular, and presents the question whether they should be overruled. I want to just point out, I don't know if people will find this interesting, but I sort of did, which was that at the cert stage, that was not the case. When the state filed its cert petition last summer in June 2020, its brief stated, and this is a quote, "To be clear, the questions presented in this petition do not require the court to overturn Roe or Casey. They merely ask the court to reconcile a conflict in its own precedents." Now, I don't know that that's really true of this issue. I'd like maybe to talk a little bit about that, whether it's possible that this case could be decided without assessing Roe and Casey. But why did the petition put it that way? They were not asking that. And of course, the brief now on the merits, now that cert has been granted, says this is a case is about overruling Casey and Roe. Starting last June, when the court first got that petition, everyone knows that overruling an established precedent is very serious, especially this one, which has so much political salience. And also at the time, remember June 2020, it was unclear whether there would be 5 votes to overrule Roe. Justice Ginsburg was still on the court. And the 5th vote, if there were going to be an overruling, would have to come from Chief Justice Roberts. And he, as we've already mentioned, has been somewhat unreliable as a conservative vote on highly controversial issues. Not a sure negative, but you couldn't count on it if that was your goal. So the state pitched its request as a desire to reconcile a conflict, perhaps as a way to encourage 4 justices to overcome their hesitancy and grant cert without really taking the headline, making the headline move of saying we are going to consider whether to overrule Roe v. Wade. But in a very unusual pattern, a sequence of events, that cert petition was what was called relisted 22 times. Now what that means is they brought it up for discussion once, and then each time for 22 consecutive meetings, which is almost a year long. Some justice or justices wanted to keep it on the discussion list to be considered, but without granting it. So often that means they want to do a little more research or make sure the case is in good procedural shape or whatever, but for something to be relisted that many times, it looks as if 4 votes were not yet forthcoming, you know, for whatever reason, those who wanted to grant were not able to get 4 justices to vote. Now then, of course, when Justice Barrett was confirmed on October 26th, the abortion petition continued to be relisted each week until it was finally granted on May 17th of 2021, almost a year after it was filed. And that's very unusual. So the court has had a gestation period of its own to think about what's going on, whether they're ready to take the case, whether they want to confront it head on, whether this is the right case, whether they have the votes. And they ultimately decided to go forward, which I think we have to interpret as a sign that at least 4 justices believe there are 5 votes to overrule, is they don't want to get the case and lose. So I don't know for sure if they have 5 votes to overrule Roe. It strikes me that several of them have said that they do want to, so we know about them. Justice Kavanaugh, I believe, is the only potential question mark who has not committed to wanting to overrule Roe. And if you recall, in his confirmation hearings, he famously assured Senator Susan Collins that Roe was safe in his hands to get her vote. And she believed him and has stood by that. I don't think she can enforce that in a court of law, but I guess I'd like to ask Erwin if you think that Kavanaugh is potentially the only vote that could stop the overruling of Roe, and whether in fact he will go along with that as well.
I agree with that. I mean, just to put this in context, there have been many state laws that prohibited abortion before viability. There were several that prohibited abortion after the 20th week of pregnancy. And the lower courts always declared them unconstitutional. They never went to the Supreme Court. Here, Mississippi prohibits abortion after the 15th week of pregnancy. The lower courts, the district court, Fifth Circuit declared unconstitutional. The fact that the Supreme Court took this, to me, is a very ominous sign with regard to abortion rights. And I don't think the court can avoid here the issue of whether to overrule Roe and Casey, whether they do so explicitly or implicitly. Roe says states can't prohibit abortion prior to viability. Science and medicine says viability is about the 24th week of pregnancy. This forbids abortions after the 15th week of pregnancy. Also, if the Supreme Court were to uphold this law, there's nothing magical about 15 weeks in the context of pregnancy. Why couldn't a state then make it 14 weeks or 10 weeks? In fact, why couldn't a state make it effectively 6 weeks, which is what Texas, Ohio, Iowa have done? Why can't a state then say we're going to prohibit abortions after conception, which is what Alabama has done and Mississippi has done in another law? I don't see how the court, if it's willing to uphold the Mississippi law, is going to be able to strike down any of those. So I think that the ultimate issue is the Supreme Court going to overrule Roe? They might do it explicitly, saying the issue of abortion should be left to the political process in each state, or they might just say, we're going to uphold the Mississippi law and we'll consider 6-week bans or bans at conception in other cases. But if they uphold this law, there's no doubt that Roe versus Wade is being overruled. So then, Rebecca, I get to your question. Can I count to 5 justices on the current court who would be willing to reaffirm Roe versus Wade? Well, Thomas and Alito are already on record saying they want Roe versus Wade to be overruled. There's no doubt where they're going to come out. Gorsuch is a self-avowed originalist, and Gorsuch, based on other writings, seems a sure vote to overrule Roe. Barrett is a law professor, was openly critical of Roe versus Wade and called for it to be overruled. Everything we know about her jurisprudence, what she wrote as a law professor, and we've seen as a judge, to me indicates she's a sure vote to overrule Roe. So then that leaves Kavanaugh. What is it in Kavanaugh's record that gives one reason to believe he might not vote to overrule Roe versus Wade? I mean, he only has participated in one abortion case. There was a judge on the DC circuit. It involved tragic facts of a teenage girl who was in immigration custody, was pregnant and wanted an abortion. And the government, Trump administration, was trying to deny her abortion. The DC circuit ruled that the girl had the right to have an abortion, but Kavanaugh dissented from that and wanted to deny the girl the right to abortion and spoke with derision of the existence of an abortion right in the Constitution. So I find it hard to imagine that Kavanaugh would be the vote to save Roe versus Wade. And I think the interesting question is, if there's 5 votes to overrule Roe, where will John Roberts line up? Will Roberts join the conservatives in this regard, even if he might not have been the 5th vote to overrule Roe? Roberts came on the court in 2005, and from then until June 2020, he never voted to strike down any abortion restriction. He did in June 2020, saying, based just on stare decisis, but I'm not sure where Roberts is going to come down when the court is squarely before it, as it does now, whether to overrule Roe versus Wade.
As the Chief Justice, if he did join, he could write the opinion himself, which might be something he would want to do. That's the only thing. Otherwise, I don't know. I agree with everything that you are saying there. Did you want to add anything about the SB8 case?
Oh,
we move
very
on?
much so. Just briefly, the case was Whole Women's Health versus Jackson. And we all saw on September 1st, it came to the Supreme Court, again on the so-called shadow docket, asking the justice for an emergency injunction. Texas has a law that went into effect September 1st that prohibits abortion once it says the fetal heartbeat can be detected. Actually, it's electrical activity of a heart could be detected, which is about the 6th week of pregnancy, which is before many women even know that they're pregnant. And the Texas law doesn't have enforcement by prosecution by the Attorney General or local district attorneys. Instead, what it does is it authorizes civil suits against doctors or health providers or those who aid or abet abortions. And lawsuit gets brought to enjoin this. After all, the law is blatantly inconsistent with Roe. It prohibits abortion after the 6th week of pregnancy, which is far before viability. And the district court says, yes, this is unconstitutional. The Fifth Circuit reverses, and it goes to the Supreme Court. In a very brief per curiam opinion, 5 justices, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, say there's an unusual procedural dimension to the law. Therefore, we're not going to issue an injunction. There are very strong dissents, including from Roberts and also Sotomayor. Sotomayor said, this law is blatantly unconstitutional, and surely we should allow an injunction to stop it from going into effect. Again, I regard this case as an ominous sign that the 5 most conservative justices, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, just were unwilling to block a state law prohibiting abortion, even though it was a blatantly unconstitutional state law.
Yeah, and that fact seems almost like the best evidence we have of how they're going to vote when they do it. Because it strikes me that if you're in your mind, Roe or Casey is good law, is the law of the land, you just couldn't. Procedural obstacles have not stopped them before from acting in the emergency docket to grant relief when they saw fit to protect rights. So I think the fact that, I mean, if you believe Roe, you couldn't walk away from this law. And so the fact that they could and use procedural reasons to do it is an indication that they just are already, they have their eye on overruling it. It just seems it would be hard to reconcile the two otherwise, it seems to me. So we're going to move on. My partner here is the author of this new book about how the Supreme Court empowered the police and subverted civil rights. And our next case is a civil rights case. So I think it's a perfect opportunity for him to talk to us about what developments he sees coming up there and the significance of this case, and maybe qualified immunity as well, if you want to.
There's one case that review has been granted that's going to be argued this fall, and another where the cert petition is pending that I just want to briefly mention. The case that's going to be argued is Thompson versus Clark. Larry Thompson and his wife had a week-old baby. Larry Thompson's sister-in-law was staying with them, and she sadly had mental illness. She called 911 and said that the week-old baby was being abused. The buttocks of the baby were very red. Some EMTs came to the apartment and Larry Thompson said, "You made a mistake. There's no reason for you to be here." And they thought they just had the wrong address. They came back later that night with several police officers. Thompson said, "Unless you have a warrant, you're not coming into my apartment." The officers pushed the door in, knocked Thompson to the floor. Thompson apparently shoved one of the officers. The officers took the baby to the hospital. The baby had diaper rash. There was no evidence of abuse at all. But the prosecutors charged Thompson with resisting arrest, abusing a police officer. The prosecutor then decides to dismiss the charges against Thompson, given all of the circumstances. Thompson sues for malicious prosecution. In an earlier Supreme Court case, Heck versus Humphrey, the Supreme Court said, if somebody has been convicted, they can't sue for malicious prosecution until the conviction is overturned. Well, Thompson has never been convicted of anything. Charges were dismissed. But the federal district court said, I know this makes no sense, but the Federal Court of Appeals here, the United States Court of Appeals for the Second Circuit, says unless there's an affirmative indication of actual innocence, Thompson's case has to be dismissed. There wasn't an affirmative indication of actual innocence because it was just charges dismissed. We don't have a mechanism in our legal system when charges are dismissed to declare somebody innocent. The Second Circuit affirmed and the Supreme Court granted review. Now, my hope is that the Supreme Court will reverse and say, if there's no conviction, then Heck versus Humphrey doesn't apply. But I'm very afraid if the Supreme Court affirms the Second Circuit, that gives prosecutors incentive to bring charges all the time and then dismiss the charges, knowing you protect them from malicious prosecution. The other case that I alluded to, where cert has not yet been granted, is Frazier versus Evans. And it involves the topic of qualified immunity. And I've been interested to see how much qualified immunity has become part of the popular vocabulary. When any government officer is sued for money damages, constitutional violation, there's always an immunity defense. Some get absolute immunity. Judges for their judicial acts, prosecutors for their prosecutorial acts, legislators for their legislative acts. But all of the government officers who don't have absolute immunity have qualified immunity. That means they can be held liable only if they violate clearly established law that a reasonable officer should know. And it has to be a right established beyond dispute. And in recent years, both conservatives and liberals have been very critical of qualified immunity. As the Supreme Court has implemented, it's come ever closer to being like absolute immunity. The Cato Institute on the right, the ACLU on the left are examples of those sharply critical of qualified immunity. Well, Frazier versus Evans involves somebody who was photographing the police, and the police took with the camera, arrested the individual, and the person sues the police. And there's a couple of issues that are presented in the cert petition. One is the training that the police received, is that relevant in determining if there's qualified immunity? And also in this instance, there's the question of how is it be decided if the officers violated clearly established law that reasonable should know in keeping themselves from being photographed? But the underlying issue is, will the court be moved by all the criticism of qualified immunity to make it a doctrine that's much less like absolute immunity, much less a absolute bar to recovery when government officers violate the law? So it'll be interesting if the court takes that case.
And even with help perhaps from Justice Thomas, right, who believes that as an originalist matter, there is no qualified immunity. And so perhaps he would be on that.
Maybe, but there's a wrinkle there. Prior to 1961, as you know, there were very few suits for constitutional violations against government officials, because it was always thought that you could sue a government official only if the government official was following official state policy. You couldn't sue the government official if the government official was acting in an unauthorized manner. And there were just a few hundred cases in the first 100 years of Section 1983. Then in 1961, in Monroe versus Pape, the Supreme Court said, you can sue a government official for money damages whether the government official is following state law or violating state law. And there was an explosion in 1983 suits, and the court then comes to develop absolute and qualified immunity of defense. Justice Thomas believes that Monroe versus Pape was wrongly decided, and he would overrule Monroe versus Pape and also overrule immunity. So it's not that Justice Thomas is going to be a friend of civil rights if he does that. Quite the contrary. If you overrule Monroe versus Pape, you're going to make it so difficult to ever sue government officials for violating the Constitution.
But if you do, they won't get qualified immunity.
Right, exactly.
Right, many fewer cases, but
exactly.
But it's such an important topic in public discourse with all the events of the last year. I don't know whether to hope that they take it or not, but it's definitely something that needs to be addressed. So we're going to talk next about the state secrets privilege. I wrote my law school note about this actually, but I don't think anyone else has really paid much attention to it. You hear very little about it for decades. And then suddenly this term, there are two cases on the docket involving the state secrets privilege, both from the Ninth Circuit. In both, the government lost below and is seeking review, just to set it up. And maybe that doesn't bode well for the claimants here. We'll have to see. But to me, the state secrets privilege is important and interesting because it brings out the tension between the transparency that we need to have in a robust judicial system of protecting individual rights, candor about how government acts, reasons, the fount of due process and of fair government all comes from a certain degree of transparency, all balanced against the government's asserted need to protect us by keeping certain matters secret for the sake of the safety. But the important feature of a state secrets privilege is that it gives the executive branch the power to decide which things need to be kept secret. Normally, courts will decide that. And in a judicial proceeding, what the state secrets privilege in its most aggressive form says is that once the executive asserts it, that's it. And the court doesn't get to reassess whether it's well asserted or whether it's outweighed in some cases by the need for disclosure or that sort of thing. And so it shifts this checking function that the court usually plays against an executive branch generally in how it exercises its authorities. It replaces that checking function with deference to the executive, unreviewable deference really. And usually when a privilege is asserted, the case must be dismissed because there's not enough there to continue to prosecute the case, whatever it is. And that's what's happened in this case. The first case of these two is called Zubaydah, US versus Zubaydah. And it involves a lot of darkness. Zubaydah was captured in Pakistan and was held at several of the so-called black sites, secret places used by the CIA to do interrogations. He was later transferred to Guantanamo, where he still is. Zubaydah was brutally tortured by the CIA using contractors, psychologists, and private companies who carried out the enhanced interrogation techniques, I guess you would say, in horrific ways that are very hard to read actually in the briefs. But in a complicated set of proceedings in Europe, it has been determined that some of this torture of Mr. Zubaydah took place in Poland, and the Polish government is taking a look at it. And in conjunction with looking at that, what happened in their territory, the Polish prosecutor is seeking information about what happened to Zubaydah. So upon the request of that Polish prosecutor, Zubaydah requested from a district court in California subpoenas against two of these private parties who allegedly participated in the design and implementation of the torture used on him. So it's between Zubaydah and two private people, but the US intervened to prevent disclosure and succeeded in quashing the subpoenas. The Ninth Circuit found that there were basic facts that could be disclosed without harming national security, and that much of what was being sought had already been disclosed in prior proceedings. And it held that the district court should have separated privileged from unprivileged material in an effort to offer release of things that didn't qualify for privilege, rather than just outright dismissing automatically as soon as privilege was invoked. So the issue really comes down to whether that kind of determination made by the Ninth Circuit gives adequate deference to the executive branch of government. So it really puts into stark relief the question of deference or abdication, if you want to use a strong word, by the court to executive branch to determine the contours of what it will or will not release on national security grounds, or whether there should be some check on that by the court. I want to give a shout out to my colleague, Professor Hannah Gary, who submitted a wonderful and compelling and if heartbreaking brief, amicus brief in this case on behalf of other torture survivors. And she makes a really interesting argument, which is that the government's, our government, the US government's treaty and statutory obligations to avoid and reject torture, as well as to remedy and make reparations for past torture, oblige the government to read the privilege narrowly in this case, because they have an obligation under the treaty to assist the Polish government in its investigation of what happened at the Black site. So it was an interesting brief filed by Professor Gary. So do you want to say anything about that, Erwin, or talk about the other case?
Sure. There have been a number of cases prior to this where people who claimed that they were brutally tortured sued, and the cases were dismissed based on the state secrets doctrine. There's a case involving a man named El-Masri, and Jane Mayer in her book, The Dark Side, tells in detail the story. He was picked up in Europe just by mistake. His name was confused with somebody else. He was taken to the dark side, and as Jane Mayer describes, he was brutally tortured, and he didn't have any information to give. And so the people at the CI said to up the enhanced interrogation. The torture became even more brutal. When they realized they made a mistake, they dumped him on the streets of Albania. He sued the United States government, and the Fourth Circuit said it had to be dismissed because of the state secrets doctrine. And then there was a case in the Ninth Circuit, Data Jefferson. There was a suit against the company that flew the planes to take people to the Black sites. And again, in the complaint, just horrific torture being described. And the Ninth Circuit saying it had to be dismissed based on the state secrets doctrine. So I think what Rebecca said, what you say here is absolutely right in terms of this is about whether or not we're going to be able to hold the government accountable when it is some of the most abhorrent things that a government can do. It was an opinion, if I remember right, in the Ninth Circuit written by Judge Richard Pius, who's one of the more liberal judges on the Ninth Circuit. The Supreme Court taking it is not a great sign. And then they took a second state secrets case with, it's a different issue, but still the same doctrine. It's FBI versus Fazaga. And this involves the relationship between the state secrets doctrine and the Foreign Intelligence Surveillance Act. It's a suit by Muslim men who said that their conversations were illegally intercepted. And the district court said, well, the extent to which the government was engaged in this was for national security, state secrets. But the Ninth Circuit, an opinion by Judge Marsha Brazan, says the Foreign Intelligence Surveillance Act creates a private right of action for those who are subjected to electronic surveillance in violation of the statute. The statute that creates the private right of action should take precedence over the state secrets doctrine, which is just a common law doctrine. It doesn't come from the Constitution or any statute. And the Ninth Circuit says to the extent that there's a statutory claim, it preempts the state secrets doctrine from applying. Again, like the case, Rebecca, that you talked about, you have a liberal judge on the Ninth Circuit. Both of these opinions are very thorough and well-reasoned, but the Supreme Court does have a pattern of reversing the Ninth Circuit, especially in high-profile cases like this.
Yeah, it'll be interesting to see, since nothing really from the Supreme Court on this since about 1953, I think, was the last big case on state secrets from the court.
Right.
So
The Reynolds case.
Reynolds, yeah. So we're going to now talk about another one that's household word, I guess, in terms of what's going to be heard on the docket this term, and that is the Second Amendment case. It's called New York Rifle and Pistol Association versus Bruin. And I'm going to ask Erwin to talk about the facts of the case, but I just wanted to mention that this is another one of those divisive cases where the court didn't grant cert for a really, really long time on any gun cases. Not that there weren't any to grant. There were many that came up. They denied cert in all of them. If you will recall, the right to bear arms as a Second Amendment individual right was first recognized in 2008. And since then, the only case they decided as a follow-on to that radically new decision was to decide that the Second Amendment applies to the states as well as to the federal government, but nothing about the scope of it, how it balances out against public safety, what type of scrutiny it used, where the right exists, anything like that, which you would normally expect from a new emerging area of law. The court will incrementally build it, shape it, and it'll become whatever it is. But nothing has come out of the court on this issue for over 10 years. And now they've granted cert on a case from New York, and former Solicitor General Paul Clement is the lawyer. So it's going to get a strong argument in favor of expanding the right. You know, it just bears, unfortunately, a risk of looking very partisan, but let's talk about the issues. Erwin, do you want to explain how it came
Sure. Oh, I think you set it up perfectly. From 1791 until 2008, not one federal, state, or local gun regulation was struck down by the Supreme Court. In the handful of cases about the Second Amendment, the Supreme Court said it means what it says. It's a right to have guns for purpose of militia service. And then in June 2008, the court decided the case you just mentioned, District of Columbia versus Heller, involved a 35-year-old DC ordinance that prohibited ownership and possession of handguns. Justice Scalia wrote the opinion for the court, joined by the 5 most conservative justices on the bench at the time. And he said, the Second Amendment protects the right of people to have guns in their homes for the sake of security. It was just about the right to have guns in the home, and he was clear it's not an absolute right. The government can prevent people from having guns if they have a felony conviction. He said the government can prevent people having guns in places like airports or schools. He said the government can prohibit people from having especially dangerous weapons like a bazooka. And he didn't specify what level of scrutiny should be used for this right. And as you alluded to, there was over 100 Federal Court of Appeals decisions on various aspects of the Second Amendment. And the Supreme Court denied review in these cases. About a year and a half ago, there were 10 Second Amendment cert petitions before the court, and the court denied cert in all of these cases. Here's my theory. I think the 4 most conservative justices weren't sure Roberts would be a 5th vote with them to strike down restrictions of guns. But once Barrett came on the court, they thought they had their 5th vote. In fact, when she was a judge on the 7th Circuit, she, in some opinions, struck down restrictions on guns, took a very pro-gun rights approach. And I think they took this case knowing that they've now got 5 votes, even without Roberts. It involves New York City restriction on having concealed weapons outside the home. You need to show a need to have a concealed weapon, and the criteria for possessing a concealed weapon are very restrictive. So ultimately what this case is about is there a right to have guns outside the home? Is there a right to have concealed weapons? And as with regard to abortion rights, if I count votes, I can't count 5 votes to uphold the law here. I think what we're going to see is a major decision substantially increasing Second Amendment gun rights.
Erwin, do you see any potential on this one to go small? One of the issues is that the person who decides whether the permit will be issued for someone who wants to carry a concealed weapon, one of the arguments is that that person has too much discretion. So it seems to me that if they wanted to be incremental, they could focus on perhaps the fact that the criteria may not be as clear as they are, or that the person making the decision about whether someone gets a license may be given too much latitude and not enough accountability for that decision, something like that, which could decide the case really on the more due process, these sort of procedural grounds of the license, rather than on the underlying Second Amendment right itself.
Perhaps. We know that Thomas, Alito, and Gorsuch want the court to take the Second Amendment and rule big with regard to it. They've dissented from denials of cert. There was another case coming out of New York a couple years ago that got dismissed as moot, and they were angry that the court was dismissing it as moot. So now we come back to Kavanaugh and Barrett. Each had a track record on the Federal Court of Appeals. Kavanaugh was very aggressive in the DC Circuit in striking down gun regulations, striking down restrictions with regard to automatic weapons. Barrett was very aggressive on the 7th Circuit in striking down restrictions on guns. So I think here the conservatives have 5 votes to rule broadly, even without counting John Roberts.
And for those who are interested in originalism, I mean, this is a territory where originalism comes out, where history is relied on very heavily. It was in Heller, it is now in the briefs. But it's also interesting to notice that it plays up the problems with history being the guide, in that the history is very mixed. And the briefs, frankly, look as if they're cherry picking to some degree, because no one can make holistic sense of all of our history. There is clearly an importance placed on the right of people to have guns or the ability to carry guns in certain situations, but there's also a lot of founders' statements about they must be allowed unless they're unusual and dangerous or something, clearly anticipating that there are situations in which the state interest in public safety would have to be taken into account. And, and at the time of the founders, a gun that could shoot 3 bullets in a minute was about as fast as they could go, and we now have guns that shoot hundreds of rounds in a minute. And so the nature both of the urban or the life that we live, the society we have, and as well as the technology of guns, seems as if it's a very poor place to rest entirely on the situation of the founders, but the briefs seem to be going in that direction.
You make a great point, and it was evident in District of Columbia versus Heller, where Justice Scalia's majority opinion was very originalist, but Justice Stevens in dissent decided to write on Justice Scalia's turf and say from an originalist perspective, it's wrong. I mean, start with the text of the Second Amendment. A well-regulated militia being necessary to security of free state, the right of the people to keep and bear arms shall not be infringed. That seems to say this is about militia service. You go back to when it was proposed, and there was initially a clause in it that gave an exception to militia service to conscientious objectors, seeming to be about militia service. You look at the language. We can argue, what does it mean to keep and bear arms? What's a militia? And there's arguments to be made on both sides from an originalist perspective. And I agree with you, Rebecca. I think that what each side does is cherry pick. You look for the aspects of history, of original meaning that support your side. People have described this like when you go to a cocktail party and you look for your friends, the lawyers look through the history and pick what supports their side. And there's plenty for each side here. It really points to the inconclusiveness of originalism.
Speaking of cocktail parties, if you want to be cool and sound really in the know at cocktail parties these days, you need to know about the so-called shadow docket. And everything you need to know, we're going to tell you right now. We only have a few minutes left before we move to questions, but we wanted to address it because it really is something that is getting a lot of attention, and for good reason. The shadow docket is a term coined by a law professor to describe the emergency petitions that are sent to the court outside of the usual cert process. And there have always been a few of these every term, but what is new is both the number of them, how they are being used by the court, and the process. So I can specify a little bit, and then I want to ask Erwin for his thoughts. But the concept of emergency petitions is just that sometimes things happen when the court's not in session and things need to get resolved. There are people being executed and they want to put forth their last minute petitions to the court, et cetera. So there has to be a process for doing that. Generally, the rubric for issuing emergency orders has been sort of just hold things in check until we can decide them on the merits. Preserve the status quo, don't make new law, don't make it any more fuss than necessary, and just try to keep things going as needed to avert disaster until the case can be decided in whatever form it needs to be. That's not how it's going now. The court is reaching out to decide cases. And the thing is that when a court decides a case on the emergency docket, there are no briefs, there are no oral arguments, there are no written opinions signed by justices with reasons. And in my classes, when we talk about the legitimacy of the court and how do you justify an unelected court in a democracy, one of the first things you always say is, well, they act in individual cases. They're accountable to the person on whom they're acting. They listen to arguments on both sides. They issue opinions. They take personal accountability by signing the opinion, and they give written reasons that can be criticized and reviewed. And that's one of the checks we have on the sort of tyranny of an unelected body. Now, those things all go away in the emergency docket. And so it's worrisome when that docket is used to make new law or to radically change the status quo. And that has happened in a few cases, quite a few cases actually, recently. And it's giving law professors a lot of heartburn to think about how we ought to think about this as some kind of court reform needed to deal with this problem. And on top of that, this court has been using them inconsistently, right? There's some where they'll say, oh, we can't act because of procedural problems, like the Texas abortion case. Or there's some where they'll say, oh, there's some procedural problems, but the right is so important that we're going to protect it anyway for a religious liberty claim, et cetera. And so there's inconsistency, but you can't attack inconsistency if you don't have written reasons or a court of review or a sideways type of review. And so it's something of a nightmare for those of us who are interested in the legitimacy of the court. I wanted to hear Erwin's thoughts on that.
You're absolutely right. There's been a tremendous increase in the shadow docket in the sense of the Supreme Court handing down important rulings that come in the context of emergency motions. We saw this start during the Trump years. I'll just give an example there. When Congress refused to fund a border wall, President Trump took money on his own from the Defense Department to do so. And a federal district court issues a preliminary injunction against that. That seems basic constitutional law. Congress has the spending power. The Supreme Court on the shadow docket stays the injunction so President Trump can do this. Or we saw it several times in the election a year ago, or a year ago spring, when a federal district court in Wisconsin extended time for the receipt of absentee ballots because of just delays in processing them and getting them in and back. The Supreme Court, the day before the Wisconsin election, overturns what the lower court did and said, no, you can't have an extension. There are a couple of other cases coming from other states where the federal district courts extended the time for absentee ballots or made the requirements more lenient. And then the Supreme Court steps in and says, no, you can't do that. Again, this is all is what Rebecca's talking about, is on the shadow docket. And then there were a number of cases that involved religions going to the Supreme Court for injunctions with regard to governor's orders that are imposed to limit the spread of COVID. And there was a case in May 2020 where the court 5-4 refused to give the injunction, ruled against religion. Case in July 2020 where 5-4 the court ruled against religion, denied the injunction. Both of those had Roberts, Ginsburg, Brierson, and Kagan the majority. And then in November of 2020, and again in April of 2021, there were a couple of cases where 5-4, the Supreme Court issued injunctions in favor of religion and against the governors, with the 5 being Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. And of course, what happened just 3 weeks ago on September 1st, where the justices refused to issue an injunction with regard to a blatantly unconstitutional Texas law. So Rebecca, I agree with you in terms of the court's inconsistency. But the point that I would make about what's wrong with the shadow docket, and I haven't seen enough discussion of this, is a grant of an injunction by a lower court is only supposed to be overturned for an abuse of discretion. The denial of an injunction by a lower court is only supposed to be overturned for abuse of discretion. Abuse of discretion is a very difficult standard to meet. And I know that all of the federal courts of appeals take very seriously the standard of review. If you file a brief in the Ninth Circuit for each argument, you got to have a section of what's the standard of review. And if it's abuse of discretion, it's a very difficult standard to meet. What bothers me about what the Supreme Court is doing in the shadow docket is they are completely ignoring the standard of review. They're treating each issue de novo on the merits. And that's where I would be very critical of what the court is doing.
And often without benefit of a lower court decision at all, because they'll skip the intermediate court, or they will rule on things that haven't been had opinions issued. So it's just a very bare bones, and it really does take on this affect of looking much more like a political process where you go to for somebody that likes you to ask for something you want and you get it, which we don't want to think about courts as being, as opposed to a rule of law where you have something on your side, you make your case, the other side makes their case, there's considered judgment, there's time, and there's a record of all the proceedings. So I think it's a very worrisome trend, and I hope it won't continue. It's very aggressive, really, as a way to sort of avoid the usual procedures that protect some of the legitimacy of court decision making. I want to just finish and then with a quick thing from you, Erwin, because you've been involved in a lot of the proposals. If there's anything you want to say to us about the proposals for court reform, is there anything that that's particularly noteworthy on that?
I don't think there's going to be any major court reform. With regard to expanding the size of the Supreme Court, it's certainly possible. As you know, the size of the Supreme Court is set by statute, not by the Constitution. I think there's an argument that says we should expand the size of the Supreme Court to restore ideological balance. Did you know that between 1960 and 2020, there were 32 years with a Republican president and 28 years with a Democratic president? In 2024, it'll be exactly 32 and 32. But between 1960 and 2020, Republican presidents put 15 justices on the court, and Democratic presidents put only 8 justices on the court. That helps explain why we have the court that we do today. And so there's an argument that we should expand the court to have ideological balance. But any bill to expand the size of the Supreme Court is sure to be filibustered by Republicans in the Senate, and there's no chance to pass. In terms of expanding the size of the Supreme Court, well, I don't think that could get past a filibuster, but nor do I think it's likely that term limits will happen for Supreme Court justices. I'd favor 18-year non-renewable terms. Life expectancy is thankfully so much longer now than in 1787. In 1787, when the Constitution was adopted, it was 36 years old. Think of Clarence Thomas. He was 43 when he was confirmed in 1991. If Thomas stays on the court until he's 90, which is the age Justice Stevens retired, he will be a Supreme Court justice for 47 years. Or Elena Kagan was 50. Amy Coney Barrett was 48. If they stay till they're 90, we're talking about people being on the court for over 40 years. That's just too much power in one person's hands for too long a period of time. And I think there's support on both the left and the right for term limits, but I think it would take a constitutional amendment. And I don't see any constituency that cares enough to do the work to get a constitutional amendment passed. So I'm skeptical that the president's commission on the Supreme Court is going to lead to any major reforms, certainly not those.
Thank you for that. That's interesting. Margaret, I think we're ready to take some questions if you have some for us.
I do. And I'm going to go back to the very first one, which goes back to the religious privilege question, which is, do you think that SCOTUS will, if they're giving Christians more religious privilege, do you think that any of the other minority organizations or religions will also be getting any consideration from that group?
Erwin?
I think so. I think these are justices who want to very aggressively protect free exercise of religion. And I think the protection that they're going to be giving to Christians is going to cause them to also give protections for other religions as well. I think the place we're going to see a lot of litigation coming up is people who want to discriminate on the basis of sexual orientation or gender identity, claiming their religion requires them to do so. A year ago, June, the Supreme Court said that federal employment discrimination law, Title VII, prohibits discrimination based on sexual orientation or gender identity. There's a lot of cases coming up involving employers who say, I, based on my religion, should be able to discriminate. Where there's cases coming up involving businesses, bakers, florists, photographers, stationery stores that don't want to serve same-sex couples. I think when the court establishes precedents in these cases of a right to violate a law on account of religious beliefs, I think that's going to carry over not just to Christian religions, but to minority religions too.
Another question that came in is, if the court does overrule Roe versus Wade, what do you think that suggests for other constitutional privacy rights, and which of these rights might be in line for modification or limitation?
Well, maybe I'll take a stab at that. One thing about abortion is that since Casey was decided in 1992, it has been treated as a unique right under the Constitution. There's a special test for it that doesn't apply anywhere else, the undue burden test. It's not called a fundamental right anymore as it was in Roe. It's now a liberty interest. And I think the court has made clear, even under existing precedent, that it is to be treated under its own set of rules. That might help insulate other rights. Once, if Casey were overruled, it might help insulate, because the test that Casey established doesn't nominally really apply to any other rights. And in theory, the jurisprudence of fundamental rights, which are sort of separate from the abortion right, could still survive intellectually. Now, whether they would also want to go after some of those rights, especially involving same-sex marriage or sexual orientation, that would be a different effort, I think. I don't think it would follow in any kind of logical way or inevitable way from a cutting back on the abortion right. Do you agree with that, Erwin?
I think you make a great point, though I perhaps am less sanguine than you are, because I think the underlying question is, should the court protect aspects of privacy and autonomy that aren't enumerated in the Constitution? And there's a whole host that have been protected: the right to marry, the right to procreate, the right to custody one's children, the right to keep the family together, the right of parents to control the upbringing of their children, the right to purchase and use contraceptives, the right of competent adults to refuse medical treatment, the right of consenting adults to engage in same-sex sexual activity. To me, what's notable is that the most conservative justices, say Scalia and Thomas, have taken the position that all of these rights are wrongly protected by the court. All of them should be left to the political process. Scalia and Thomas certainly said that with regard to marriage equality. Scalia said that with regard to the right of parents to control the upbringing of their children in Troxel versus Granville. Justice Thomas, before coming on the court, said Roe and Griswold that protected the right to contraceptives was unconstitutional. And I worry that if the court overrules Roe, it's going to say, this is a matter that's left to the political process. And from an originalist perspective, none of these rights are protected by the Constitution. Now, I don't see some of them likely coming back with the court. States are much less likely to regulate contraception than abortion. But I really worry whether or not we have a court that would protect these rights. Rebecca, even take Lawrence versus Texas, that involved whether or not a state can prohibit private, consensual, adult same-sex sexual activity. You had there the most conservative justices, Scalia and Thomas, dissenting. And I think if you look at the justices who have joined the court since then, they're much more likely to agree with them than the majority. I hope I'm wrong.
Margaret?
Sorry, I had to move my cursor a bit. So there's two other questions. There were some questions that alluded to the makeup of the court, but I think you've addressed that. So I'm going to go to another question, which was, Rebecca, you alluded to Justice Barrett's question in her separate opinion, joined by Justice Kavanaugh in Fulton versus City of Philadelphia, apparently in response to Justice Alito's statement that it's high time for us to take a fresh look at the free exercise clause demand. What should replace Smith? What do you and Dean think that the standard is likely to be? An entirely new standard or a return to Sherbert versus Verner?
I haven't really thought hard about what the new standard might be if they do overrule it. I mean, the biggest trap, so for people who aren't familiar with those cases, I should just explain that this case, Smith, that Justice Barrett said she wasn't ready to overrule, even though she doesn't like it. That case says that states may incidentally burden religion if they don't intend to. So a law of general applicability, like a drug law that happens to fall negatively on someone who happens to want to do something that's swept up into the coverage of that law, like in that case, it was a Native American person who used peyote in the practice of his religion. An incidental burden like that, too bad. Fine, it's okay, it's not unconstitutional. The only thing that's unconstitutional is if the state intends to burden religion. Now, it's interesting how the sort of constituencies have switched here. Back when that case was decided, it was Justice Scalia who wrote that opinion, the most conservative justice on the court, because it was viewed as a way to protect fringe religions primarily, right? That he didn't have much interest in what happened to some peyote user in Oregon and whether he got the brunt of federal anti-drug laws. It didn't bother him much. And I guess, but now with greater focus on religious freedom and anti-discrimination laws, as Erwin said, butting up against some practices or belief systems of certain religions, right under Smith, you wouldn't get an exemption from Title VII to discriminate on the basis of sexual orientation because it's not intended to burden religion. And it had law of general applicability. And so if you want to have a different outcome there, that such as Erwin was discussing, where you're protecting these people who are claiming religious exemptions, not from their legislatures, who might well give it to them, by the way, but from as a constitutional entitlement, if you're trying to protect them, you have to overrule Smith, I think. And so what would replace it? Unfortunately, in my opinion, it raises a very ugly question of what is a sincerely held religious belief. And so far, the court has managed and wanted to stay away from that question, right? Because how do you show that you really need to smoke peyote? Or how do you show that your religion really doesn't allow you to bake a cake for a gay wedding? We never wanted to go into the minds and consciences of individuals. That itself can be an invasion of privacy. And so the court has tried not to have tests that require it to do that. But it seems to me they're running into the danger of that if they take away the Smith rule, which is quite clear that there's no intent, there's no unconstitutional action. So those are my thoughts.
I want very much to agree with you. Justice Alito, in his dissent in Fulton, joined by Justice Thomas Gorsuch, says, if the government significantly burdens religion, it has to meet strict scrutiny, necessary to achieve a compelling purpose. As the questioner points out, Justice Barrett, joined in full by Justice Kavanaugh, says, we don't need to reach this question here. And when we do, there'll be hard issues to resolve. But remember, she didn't need to reach the issue to come to the results she wanted, ruling against Philadelphia and in favor of Catholic social services. I think the court will adopt strict scrutiny. And remember, the Religious Freedom Restoration Act that follows Smith, that still applies to the federal government, uses strict scrutiny. And the conservatives have applied it. Think of Burwell versus Hobby Lobby involving the contraceptive mandate. That was a Religious Freedom Restoration Act case, and they used strict scrutiny. But I would just end by pointing to what you said, which I so agree with. If the court goes in that direction, it's going to have to face the very hard questions of what is religion and how do we determine what's a sincerely held religious belief? So long as we weren't giving exemptions for religion, the court didn't have to face those questions. But if they're going to go down the path that the conservatives want, those questions will become very salient. I think they're enormously difficult to answer and very divisive to answer.
So I am very aware that we have 1 minute left, and I have 2 questions that are left, and you can choose whether or not you want to answer. But one of the comments was, recently we've seen Justice Barrett and Breyer trying to defend the court against the notion that they are politicians in robes. So at what point does the court start to lose its authority as an impartial judicial body and begin to jeopardize the rule of law? That's a big question with 1 minute. So I don't know if you want to take that, or we can save that for another day when we've seen some rulings this year. I'll leave it to you.
I think, Erwin, you should have the last say on this one. Your head is shaking. You need to say something.
I think the justices doth protest too much. I did an op-ed in the LA Times this past Sunday that began, if the justices don't want to be seen as partisan hacks, They shouldn't act like partisan hacks. The reality is their ideology is determining the outcome. And as Rebecca and I said from the beginning, we have a very conservative majority on the court. When will the court lose its legitimacy and authority? I don't think we can know at this point. It happened in the 1930s. It could happen again. And if I have the last word, I just want to say, Rebecca, thank you so much for including me. This has been such a pleasure to do this with you.
It was a joy to have you here, and really a fun, even if perhaps muted in terms of our optimism, still an important inquiry about what's going on next. And I really appreciate your thoughts. And thanks to everyone for coming and listening. I hope it was interesting to you. Look forward to seeing you all again.
Thank you both very much. And thanks, everyone. Good night.